Okay, we are now on the record. This is a regularly scheduled meeting of the Baltimore County Board of Appeals. It's in the matter of Hopewell Pointe, alternate A, 8th revised CRG refinement. It's PAI number 15-0389. It's DRC number 111318D. This is an appeal of a DRC letter dated November 20, 2018. And just by way of background, this matter was first heard by the Board of Appeals a couple of years ago. The question is whether the developer is entitled to a limited exemption from the development process. We ruled 2-1 in that case that the developer was entitled to such a limited exemption. The community appealed to the circuit court, and by order dated August 16th, 2021, the circuit court reversed the Board of Appeals decision and remanded it for further consideration. The reason for that was that the standard applied by the board in the case that was reversed was too narrow, holding that we needed to consider essentially all of the circumstances of the development, not just the very narrow criteria that were used in our opinion in that case. We met, I don't have the dates in front of me, but we met because two of the members of the original board were now gone from the board. We requested a little bit of rebriefing and argument, and that was done, I believe, on April 7th, if I'm not mistaken. And so the narrow question before us is whether this alteration of this development plan is entitled to a limited exemption or whether it's a material amendment. And again, just by way of background, what was originally proposed was a marina and restaurant for the tip of Hopewell Pointe, and the developer is proposing that that commercial development be modified to a condominium development of fairly small order and in line with all of the other residential components of the development. So I think that's the background. Have I missed anything that's relevant there in terms of the context here? No. So I don't, it strikes me the case is extremely close. The developer's position, which I think is rational, is that the residential development is much reduced in scope and impact in particular, much less impact than the commercial development would be if it were concluded, if it were implemented. And the developer, the community's position is that impact, well, the community is a little fuzzy on the extent to which impact is impacted, but I think primarily the community's position is that this is a qualitative change, not simply a quantitative change. It's a qualitative change. That is, it goes from commercial to residential, and the community relies for its persuasive value, not its precedential value, on an unreported decision from the Court of Special Appeals, Meadows of Green Spring Homeowners Association, Inc. v. Foxley Enterprises, Inc. This is an unreported decision dated October 22, 2004. And it's case number 2170, September term 2003. So I don't know who wants to go first. I can go first. Anyone else can go first. Does anyone have preference there?
You can go first, Mr. Evans, but I just wanted to bring up the point. I know you said that that Green Spring Station case was used for persuasive, but I don't think the rules even allow us to use that even for persuasive authority.
Well, you might be right on that.
I think Maryland Rule 1104 says we can't use unreported opinion. We can't cite to it, and we can't use it. Says neither precedent within the rule of stare decisis nor persuasive authority. So, but it is there.
Right, it's out there. And I guess you're right, it's not persuasive. I guess that the extent to which we can consider it is it's a writing out there by 3 judges. So maybe it's something like maybe it has the status of a law review article or less. You know.
I find that it creates more questions than it answers.
Okay.
That's what I think about that opinion. So though it had some interesting points, but it creates even more questions.
Well, maybe you could elaborate on that. Do you have a view on this matter?
Do I?
Yeah.
Well, so I guess that is, you wanting me to go first?
Well, I can go first. I thought maybe your comment suggested you were. I get the sense no one wants to go first here.
I'll go first. I'll talk through some things, but I don't think I can give my definitive yet because I have struggled with this, which doesn't seem like the biggest thing in the world, but to the community it is, and I'm sure to the developer it is, but it's interesting. What it does for me is we have a contrast between the academic and the pragmatic. And the one thing that is clear is that the first go around, we now know for sure that, density doesn't have to be triggered before you can, determine whether it's material or not. I don't know if that was a Scrivener's error or whatever that was in the last opinion, but that is clear. I think conversely too, one thing that the Meadows of Green Spring kind of alludes to is that just because something's smaller doesn't mean that it also is disqualified for analysis to see if it is a material amendment. And Mr. Evans, I think your point using the term quantitative and qualitative, there's 2 different versions of what would make something material. If it's bigger, of course, it definitely might be material, but if it's of a different nature, it might be in fact qualitative as well. What bothers me always in these things is there's a way that this has been handled procedurally for years. I think Mr. Holzer brought this up in his arguments. And it seems that has been carried through with the county, and that's what the developer and his attorney relied on in this situation. It's like no one's trying to do an end run or sleight of hand. They applied for what they believe they should get based on what has been given out in the past. I mean, that's what you do. So now we, as this board, are charged with doing this great statutory interpretation of what maybe should have been done or how these statutes should be read. I think somewhere we read in, I think it was the it's actually in the Greenspring case, they're talking about this, the guide there of figuring out whether a slight or minor insignificant change to a plan, or whether or not it has a significant impact on the site or adjacent properties, which again, we don't know what that even means.
Right.
Common sense wise, let's just call the elephant in the room is what it is that there's nothing on the site. And that's what it is. And I understand, and this is often the case when you have a site that has nothing on it, the pushback from putting something on it is understood, but that is not the comparison that we have in this situation. The material change is not from tabula rasa. The material change is from a restaurant in a marina. And as you said, Mr. Evans, this looking at the two condos, I think 14 units in each, doing some math, there's a good argument that this is quite less intensive, less macadam, there's the benefits of having people who live in the community rather than visiting a community, things of that sort.
Drunk drivers.
Drunk drivers. So looking at all those factors, it's definitely the impact might be not significant in relation to a restaurant, not to a vacant lot, of course. But then again, and looking at, plain meaning rule situations without getting into the application of how this has been interpreted in the past, when you're looking at something being material, the qualitative change is that folks could have said, I liked living there because I was going to get a restaurant in a marina, which was an amenity I was willing to, give up a little traffic and stuff, or as an amenity that I thought was good for me. Having extra buildings of condos was not something that I had baked into my cake per se. So I guess there's an argument there that qualitative change would be material. So the whole Meadows of Greenspring, the 8 stories down to 2 or whatever, I think in reading that opinion, I think it's more of how the board came to their conclusion than what the conclusion is. Basically, they were talking about how, the county historically had dealt with reductions in size as not being material, which is not the test. And also there was things on the record how the smaller building would have a significant impact. The evidence in this case, a good portion of it dealt with how it would be different from the vacant lot, which is problematic because that is not the case. And I think Mr. Rosenblatt kind of brought that up, that basically the floodgates had been opened for evidence. We weren't dealing with the limited exemption anymore. It was basically dealing with the case of why they don't want this in the first place. And most of those complaints were dealing with they wanted status quo to continue, and that's understandable. So what I do know,
I think one of the things was that there's sewage and septic and water issues. I guess it's sewage, not septic, but it's sewage. And it struck me at the time that there's more stress on the infrastructure with the marina and restaurant than with
one with
the buildings. But anyway,
and
I didn't mean to interrupt. But.
No, I appreciate it. So it's just, but one thing to make clear is that, in these type of cases, we're not determining whether or not the county's determination was arbitrary, capricious, or anything of that sort. We're stepping into their shoes and we're making the determination ourselves. Now that it's been clarified by the circuit court that there's no requirement of density for it to be material, that the decision comes down to us. And I think basically that's why the Meadows of Greenspring isn't very helpful, because really the decision comes down to us unless, you have nothing to base your decision on and it's completely in left field. I think the discussion that we've had right here between the two of us, I'm sure Mr. Pennington will add some stuff too, shows us that there's significant evidence either way that would support this board going either way. It's our decision for determining what is material. And that is what is so painful about what we're doing here, because we have no guidance other than basically our thoughts on determining the evidence that came before the board. Mr. Pennington and I had to review the record because we didn't have the opportunity, as you did, Mr. Evans, to hear as it was coming in. So that's where I am waffling. I have framed the issue there, but I'm still kind of, I don't think I've ever been in this situation this late in the game. I've read everything, and I still would like to hear from the two of you. I guess that is the nature of our deliberating.
So the one question I would have, and I must say, I agree with you. I find myself woefully undecided. One thought I had the other day as I was, I don't know, taking a shower or something was, who has the burden of proof here? Is the burden of proof on the developer to show that this is a limited exemption? Or is it on the community to show it's not a limited exemption?
I think it's de novo. I think the burden would be with the developer to present the information, just like they were presenting it to the county, to say that here's the information, we should get an exemption. I think they're doing the same for us, and they have to tell us. That's the way I would see it. I have no case law to support that notion, but that seems to be the logic.
You would think, that's sort of what I thought. And so you would think if one's mind is in a state of perfect balance, complete equipoise, then that means whoever has the burden of proof hasn't satisfied the burden of proof. That's a kind of a wimpy way out. But I toss that out there as part of the calculus. I'm not saying that puts a thumb on the scale in any way. I'm just saying that's yet one more feature of this fairly weird conundrum. I mean, honestly, I mean, part of me thinks that, you alluded to this, Mr. Belt, but I mean, part of me thinks that the community should be careful what it wishes for. The economics could change and they could end up with a restaurant and marina that I think they'd be less happy about. On the other hand, if we were to rule in favor of the developer and it were to go back to the circuit court and then the Court of Special Appeals and all of that, I mean, the developer might be frustrated here forever, well, or for years yet to come, and it might be easier to just go back to the DRC and get, find out if it's, or get, request approval of a material amendment, and that might actually be a vastly quicker race to the end here. I offer that. I don't, all of these issues they're confounding.
Maybe Mr. Pennington's going to set us straight.
I want to say the same thing you just said. I mean, when you look at it on its surface, you have the marina and the restaurant, and it would seem to me, I don't remember hearing any testimony though that people actually moved into the neighborhood or they're there with the expectation that there is going to be a restaurant and a marina. That's not to say, I mean, it's a pretty large community. I'm sure there may be, or I'm sure there are people in that community that are expecting the restaurant and the marina. So that's I'm just like you. I'm in the same spot. Like, it would seem just when it surfaced that, yeah, that's a material amendment because you're going from commercial to residential. But when you delve a little bit deeper, it's like, just like Mr. Evans was saying, it's less stress on the infrastructure. You know, and it's right now it's a green space. And I think a lot of people want to keep it as that green space. And it's not, you know, the development plan doesn't have that as a green space. It has it as a development.
Right.
So I just feel like whatever we do here, it's just, you know, it's going to go to another level, I'm sure. And then, like you said, it may go back to the Court of Special Appeals. We're not back, may go to the Court of Special Appeals. Just prolonging the case. I think you had some pretty good ideas, Mr. Evans. But I don't know. I really, at this point, I'm still on the fence with the two of you. I really am. I look back, you know, to back in '97, there was a material, you know, they applied for that limited exemption, and it was approved, going from 290, I guess, units to less. So 290 townhomes is what it was originally planned, to 117 condo and 104 villas. That was deemed as not material, and nothing was appealed or anything like that. So that went through. Is it just because this is commercial, going to residential makes it material? Or should we just stick with what the DRC did back in '97 and approved it?
Well, I mean, Mr. Belt's point, and I think he has more perspective than I do, even though I think I've been on the board now 6 years. But I think it has been the traditional view since, you know, for decades now, that when you go from more to less, then everyone views that as not material. When you go, and the more to less is typically understood in terms of density and impact and things like that. So, and I think even Mr. Holzer's argument to us when he was arguing the Foxley case, or bringing it to our attention, I should say, even he, I think, expressed some surprise, because it is contrary to the way we've always done this. Or when I say we, the county, I should say, we've always viewed, you know, going from greater to lesser as meriting a limited exemption. So, but again, I mean, I'm not sure, if I were the developer, I'm not sure which way I'd be rooting here, frankly.
To bring up something I was thinking about again, if we are to look this in statutory construction terms, if we're in agreement, and it seems like we are in agreement, that though outside of this venue, we might know what a material amendment is, if within the statute, we're not clear what a material amendment means, and so the plain meaning isn't working for us, to go outside of which, though it's not persuasive or precedent, Looking Meadows at Green Spring, in the court telling the board they got it wrong, they quoted that policy manual that says a refinement is a slight, minor, or insignificant change to amendment or plan which has no significant impact on the site or adjacent properties. Now, if you're to use that definition to give you clarity as to what the statute was meant by how it's used in practice, this would somewhat fit that definition. Or we're to believe that the county has always had it wrong. Mr. Pennington's discussion of the 1977 issue, we have to assume that that was completely wrong, and that everyone's been doing it wrong, and it's time.
But that wasn't appealed. I mean, you know, that was might have been viewed in practical terms. Maybe the candle wasn't worth the flame on that.
Well, I mean, it was much larger than what we're saying here. It has no precedent. You're right. I mean, there's no opinion telling us that. But then furthermore, gives us evidence how the statute has been used in practice.
Well, that it has, you were, I mean, it has been viewed that way in practice.
So like I'm saying, in terms of legalese statutory construction, if we deem an ambiguity, we're allowed to use that as guidance. If we deem it not to be ambiguous and subject to plain meaning, we don't worry about such things. But I think if there wasn't ambiguity, we wouldn't be sitting here staring at each other, figuring out what to do.
Well, I guess I'm gonna, I'll take the plunge here.
Right.
And I guess I'll say that I do think I don't want to rely on the case. The judges in that case note that that a factor is qualitative, not simply quantitative. Maybe the county has been doing it wrong all these years, relying on quantitative solely or primarily or solely. But I guess I'm going to say that given my reluctance to come out on one side or another, I'm going to say that that the burden of proof tilts it for me, and that therefore, I would rule that the developer has not proven that he's entitled to a limited exemption because, well, you can't make up your mind. You got to go, you got to go the other way. And so that, and as I say, I'm not sure a ruling like that is hurtful to the developer, honestly. It may be a huge time saver. But I would be fear if I were the developer, I'd be fearful of a ruling in its favor now that gets reversed in 2 years. And then, look where he is at that point. So anyway, that's I guess I would come out, I would be, the burden of proof would be enough for me to reach a decision that we're obliged to reach. We can't be a hung jury.
What say you, Brian? What do you say, Mr. Pennington?
Well,
and I'm happy to be wrong on this too, let me say.
I mean, I'm still leaning. I'm leaning to, I don't think it's a material amendment. I'm there, but I'm putting myself in that community. If I'm living in the community and they want to change the restaurant and marina into residential, maybe I want some input in that, and maybe that's what's needed, is to go back through that process and get the community input. But I don't think that's still enough. I'm still leaning towards it being not material, just because of the testimony we heard and the impact, and especially that, bringing up what you talked about, Mr. Bell, about the refinements. I think it may fit in that. I think it does fit in that, actually, the proposed change. So that's where I'm leaning.
All right.
And not to say, I mean, and I agree with Mr. Evans. I think it may, I mean, the developer may be benefited by us saying that it is material, because this could very well go on for several more years. It's been going on for several years now. But I can't use that as my rationale, so I have to
Yeah.
vote with it.
Right.
Yeah. Again, back to the academic versus the pragmatic, but Mr. Evans makes the good argument that the academic might be the pragmatic, because it might draw things out even further. So I know my philosophy to be consistent in these things has usually been to side with the pragmatic, because I do feel strongly that when you establish a process, that accepted process is what people rely on in trying to do what they're trying to do. I think what is clear, I'm sure you can make some arguments, but I think from this fact finder, I think all three of us, that we feel that there is not a significant impact different from what would be if in fact there was the marina or the restaurant. I think Mr. Evans's argument is more of not meeting the burden that the qualitative change doesn't carry the days. But and I've always first looked at what is the reason for this requirement anyhow? What are you trying to prevent or protect by requiring further review for material amendments? And I would say, without a great research of the legislative history, well, one would be that make sure you're not making amendments that cause a significant impact and harm or to the adjacent properties. And looking at that, I think it's clear that this project would not do that. It definitely would be different from what is there now, which is nothing. But that is not the comparison. That's not the Jump Street. The Jump Street is if there was a restaurant there and a marina. So I've talked myself in circles, and I would have to say that I lean with Mr. Pennington, and I totally respect Mr. Evans' opinion, because I've had it several times within this discussion. And also as I was considering this. So I can say this, though, in making that decision, I do feel confident that the three of us have given this matter our full attention. There has been, review of the record, reading of submittals, dealing with the history, though it's not persuasive or precedent, looking at the circumstances of the Meadows of Green Spring. But I think I am still persuaded that this is a refinement, which I think is a horrible word, because the refinement really is not really the appropriate term, I think, for this, but we don't have say in those type of things. But as for significant impact on the site and adjacent properties, I just don't see it. And I think I believe, and more than believe, I'm almost sure, as Mr. Rosemel has stated, we're still in a development process here. Before the building of these structures, there still is some permitting and other types of hoops to jump through for review. So there's that as well. So that's where I am. I think I'm with Mr. Pennington. I apologize for leaving Mr. Evans on an island and messing up our equipoise, and he gets extra points for the term, which I will use throughout my.
Well, let me just say this. I, though I was in a state of equipoise, and while I take some guidance from, for example, Judge Murphy in the Foxley case. He's a judge I happen to respect immensely.
Judge Meredith wrote it, though. It was Judge Meredith.
I know, I get that. Well, Judge Barbera was part of that. I mean, so anyway, but I also place great value on the views of my colleagues here. So, without wanting to appear or in fact be too wishy-washy, if the two of you have that view, then that tilts me away from equipoise, and I can in good conscience join that. I see no reason to not do that. As I say, I'm just, this is possibly one of the most difficult cases to decide in the 6 years I've been around here. And so I can go along with that. I can go along with that in good conscience. So.
All right, well, you're the chair, Joe, Mr. Evans, so it's up to you to pull the plug and call for the last vote.
Okay, well, the last vote, the consensus seems to be, the unanimous consensus seems to be that we would rule this as a limited exemption because the impact is so much less that even though there's a change from commercial to residential, and that is, of course, a difference in kind, but because we've gone from greater to lesser in a fairly dramatic way. And I think the testimony establishes that, actually, the testimony that was presented 2 years ago. So I take it that we've agreed that this is a limited, that the developer is entitled to a limited exemption. Is that accurate?
It is. And one thing I wanted to make clear from your comment, Mr. Evans, is that we are not saying that it is not material because it is less in quantity. There are instances where there can be less structure or less development that might have greater impact. The next step we have to go through is we've looked at that lesser, and we've also deemed that its impact on the site and adjacent properties is also insignificant in comparison to the baseline being a restaurant in the marina. Because I think it's very nuanced. If you make, and that's why I just do that, because the original decision by this board was very generalized, which misstated the law.
Right.
If someone were to say that the meadows of Green Spring had any bearing on this, there is a distinction in that case as well, that, not just because it's less doesn't mean it's not material. The third factor is looking deeply at it, is what impact are we having on the site due to that change, even knows that it's less. And I think we are in consensus based on what we have heard, that the worries about water, septic, things of that sort, would be present with a restaurant and a marina. So that's what makes the change insignificant. And I just offer that clarification just so we make sure we get that on paper, so we don't make any generalizations that would lead anyone to believe that we did not take this to the finish line and look at all the factors that in fact would affect a decision.
Right. Our decision is very, very, very fact specific. And we're not offering grand conclusions about criteria that apply unthinkingly across the board. I think that's what you're saying, right?
Yes, and I think Judge Hanley gave us that room in his decision. He basically stated that though the generalization was wrong, after doing the proper analysis, it still could be legitimate for us to find the same final decision. So there's that. A difference than matters of Greenspring. That court was trying to say that there was no way it couldn't be a material amendment. Judge Hanley had that ability as well to say that there's no fact finder in his right mind could ever find that to be true.
Right.
That was not done. The
Right.
charge was given to us again to be the fact finder and to make the determination on the facts.
Right. And, as one of the only remaining survivors of Judge Hanley's opinion, I have to say I agree with Hanley. I mean, I think he got it right and we got it wrong in terms of the application of the standard. I do think Judge Hanley did a better job than Ms. Murphy and I did early on. But in any event, I guess we've reached a consensus here.
Yes.
So I believe we have 15 days to issue an opinion, so we'll have to deal with that. I believe that's right. Is that right?
It is a development matter. I think it is. I think it is.
Yeah. Well, okay, well, we'll have to figure out who's gonna author this, but we can do that between ourselves. So unless there's anything else that anyone needs to say or put on the record, we can adjourn.
All right, and we shall. Gentlemen, thank you very much for a very interesting legal colloquy here.
Yes. All right, thank you. I'm going to turn us off the record now.
Thank you.
Take care, y'all.
Yeah.